Hello, my name is Barry Arrington. I'm the Chief Legal Counsel for the National Association for Gun Rights. And today we're going to talk about an amicus brief that NAGR just filed in an important Second Amendment case out of the Aloha state, the state of Hawaii. This case is Wilson versus Hawaii. And it arose when Chris Wilson was out in a national park one day, and he was approached by some law enforcement personnel, and he had some firearms. He was exercising his Second Amendment rights. And Hawaii has a very, very restrictive public carry regulation system, so restrictive that it's clearly unconstitutional under the Buren case. You might recall that Buren arose in 2022 out of New York's carry restrictions. And basically, New York said, in practically all situations, you're just not going to be able to carry any sort of firearm in public because we're not going to issue any sorts of licenses. Well, Hawaii's carry regulations are just as bad as, or not, if not worse, than New York's were, so they're clearly unconstitutional under the Second Amendment. This is a no-brainer, right? Chris Wilson gets convicted for exercising his Second Amendment rights. He appeals his conviction up to the Hawaii Supreme Court, and we're going to say, all right, Hawaii Supreme Court, go get them. Apply Buren, easy case, conviction overturned. That's not what happened. In a case that has become infamous, the Hawaii Supreme Court said, and I'm not making this up, I promise you, Buren does not comply with the Spirit of Aloha, and therefore it has no application in the state of Hawaii. Well, wait a minute, Barry. Isn't the Hawaii Supreme Court subject to the United States Supreme Court under the Supremacy Clause of the United States Constitution? Well, actually it is. The Hawaii Supreme Court has final say over Hawaii's state constitution, but the United States Supreme Court has final say over the United States Constitution. And when it comes to applying Second Amendment issues, even though it's a state court, the Hawaii court is bound by the United States Supreme Court's decisions. Now, the Hawaii Supreme Court thought it was being clever and basically cast its opinion in terms of analyzing the state constitution, which was practically identical to the Second Amendment, and then it added a couple paragraphs at the end and said, oh, by the way, it's okay under the Second Amendment too. But they're not fooling anyone, because they specifically mentioned Buren and the federal constitution. And if they're analyzing the state constitution, what Buren has to say is not relevant. What's relevant is what Buren has to say with respect to the federal constitution, which the state court criticized vociferously in very, very harsh terms, and then said, well, the Hawaii state constitution doesn't protect the right to carry arms at all, zero. So it was an end around, it was a clear defiance of Buren by the Hawaii Supreme Court. And we don't have to guess about this because they weren't very subtle in their defiance. So, for example, Buren says that the test for any law that burdens Second Amendment rights is if the plain text of the Second Amendment covers the plaintiff's proposed conduct, it is presumptively protected by the Constitution. Then the state can come in, and only if the state can demonstrate that its law is consistent with the nation's historical tradition of firearm regulation will the law be upheld as complying with the Second Amendment. Buren is basically, once you get past the plain text step, which was obviously occurred here because he was carrying a firearm, obviously carrying a firearm is covered by the plain text of the to keep and bear arms. So we're past that. It's to the history step. And the history step, as its name implies, is built on respect for history and the nation's traditions of firearm regulation. So what did the Hawaii Supreme Court do? The Hawaii Supreme Court channeled Henry Ford. What's Henry Ford got to do with it? Well, Henry Ford famously said, history is bunk. The Hawaii Supreme Court agrees with Henry Ford, and in no uncertain terms said that Buren's reliance on history was not good. So, for example, in its decision, and I'm quoting now Buren's command to find an old days analog undercuts the other branch's responsibility. Time traveling to 1791 or 1868 to color how a state regulates lethal weapons is a dangerous way to look at the federal Constitution. The Constitution is not a suicide pact. We believe it is a misplaced view to think that today's public safety laws must look like laws passed long ago. In no uncertain terms, the state of Hawaii Supreme Court said to the United States Supreme Court, "Why, you just blew it." And so after the Wilson decision came down a couple of months ago in the state of Hawaii, Chris Wilson petitioned for certiorari to the United States Supreme Court. That's where the case is now. That cert petition is pending. Now, one of the things that NAGR does in its advocacy program is it files amicus briefs in the United States Supreme Court, either at the merits stage, if certiorari has already been granted, or at the cert petition stage, urging the court to take cases. And that's what NAGR did in this situation. And what did we say in the NAGR's amicus brief? Well, first we start out by quoting the Wilson passage that we just talked about, rejecting the Supreme Court's approach to history as part of the Second Amendment analysis. And then we talk about how the Hawaii court got cute. It capped off its anti-Buren screed with a pop culture reference of all things. As the world turns, it makes no sense for contemporary society to pledge allegiance to the founding era's culture, reality, laws, and understanding of the Constitution. Quote, "The thing about the old days, they the old days." That last part was taken right out of the HBO TV series called The Wire that you might have seen from several years ago.
Well, the thing about the old days, they the old days.
So in our brief, we start out with quoting that and the Wilson Court's anti-Buren screed, and we say basically they got the wrong pop culture reference. We think the most appropriate pop culture reference, given the way the Hawaii Supreme Court has treated the United States Supreme Court, is this one from "Oh Brother, Where Art Thou?"
You ain't the boss of me!
You ain't the boss of me, indeed. That's basically what the Hawaii Supreme Court is saying to the United States Supreme Court. The problem is, under the Supremacy Clause, the United States Supreme Court is the boss of the Hawaii State Supreme Court, at least with respect to federal constitutional issues. And this defiance of the Supreme Court's authority has got to be stopped. NAGR then goes on to say that if it would be one thing if Wilson were an outlier or even unusual. But the problem is, especially with respect to gun ban issues, Wilson is not unusual at all. As a matter of fact, it is the rule. As a matter of fact, it is the unanimous rule. Since Buren, there have been 14 gun ban cases decided by the lower federal courts. The government is 14-0. Let me repeat that. Every single plaintiff that has brought a challenge to an arms ban post-Buren has failed. Now, the whole point of Buren was to say to the lower federal courts, after Heller, we told you not to be reflexively differential to legislatures when they ban guns. That was the point of Heller. For example, what other constitutional right does the government always win when its regulations are challenged? And the answer is none. The Second Amendment is unique in this respect. And then we go on and we talk about how the lower federal courts have used shoddy reasoning and clear pretexts to kind of sidestep the clear implication of Buren. And we just marched the court through all 14 of these cases. The government is 14-0 in arms ban cases since Buren. And all of the cases are run afoul of Buren's plain logic and its plain command to analyze the plain text and the nation's history and tradition. That's why NAGR filed its amicus brief in Wilson, saying we've got to stop this pattern among the federal courts of always deferring to legislative arms bans. That's what Buren more or less said. You can't always defer to the government when it comes to Second Amendment rights. We don't do that with any other constitutional right. Why are you doing it with the Second Amendment? There's no good reason. And we flat out say in our amicus brief that this is analogous to the 1950s. And how was it analogous to the 1950s? We all know in 1954, the United States Supreme Court came out with Brown versus Board of Education, which outlawed racial segregation in the public schools under the 14th Amendment. Well, what happened after Brown? Well, if you predicted that all the lower courts just fell in line and complied with Brown and said, yep, racial segregation is bad, we're not going to allow it under the federal Constitution, you'd be wrong. There were segregationist courts that continued to try to uphold segregationist laws. For example, there was a court that held that Brown only applies in the education context. It doesn't apply in the context of public recreation facilities. And then another court said Brown doesn't apply in the context of public transportation. Those cases were ultimately overturned, and for obvious reasons, because they did not comply with either the letter or the spirit of the Brown decision. But it's an example of the Supreme Court cannot hand down a case that's clear enough that a lower federal court cannot try to get around it. The obvious implication of Brown versus Board of Education is racial segregation is not compatible with the 14th Amendment of the United States Constitution in any context. Yet lower courts fought it for years until they found out that they were going to get overturned every time they did that. This is what's happening here. The NAGR, in its amicus brief to the court in the Wilson case, said you need to take this case, Supreme Court, and issue a strong rebuke to all the federal courts and state courts that have defied Buren. Not just the Wilson court, not just the Supreme Court of Hawaii, but all that are refusing to get in line with the plain holding of Buren. And that's why the NAGR is advocating in that case for the pro-Second Amendment position. You can visit us at nationalgunrights.org to find out more. Thank you very much.